Welcome to this free immigration help channel. Today we are getting into volume 22 of me answering your questions. Before I start, as always, I mentioned I'm not an immigration attorney. This is not a legal advice. All the information that I provide in my videos are directly from USCIS website, which is the official government website for U.S. Citizenship and Immigration Services, and also the Department of State. So, without further ado, let's get into your comments. First one from Abby Larson. I have been waiting for my renewed green card since May 17, 2021. I have submitted an inquiry and awaiting a response. And that was the comment on my video that I made, what if my green card expires while waiting for renewal. So in this video that this particular one, the new rule that was implemented recently by USCIS, basically extending the wait period and your legal status, which is most important, within that waiting period, which is now 2 years. I said that most likely USCIS did that, implemented that, because they are experiencing delays. Now, I'm not sure exactly why they're experiencing delays, specifically with these green card renewals, but looks like they are. And Abby, in order to be helpful more or less in this video, I'm actually gonna use this opportunity to show everyone how to navigate USCIS and specifically to find the processing times for certain applications. So this is the official government website for USCIS. We're gonna go into tools and we're gonna go to the case status online. There's a few ways to get to that, but this is how I do it, processing times. And in the form, we're gonna select I-90, which is the application for to replace permanent resident card. And from category, now I'm not sure which one is due, but I'm assuming it is either most likely a 10-year renewal or a replacement if you lost or stolen. So we're gonna do a 10-year renewal for now. We'll change it up. Looks like it's only Potomac Service Center that processes these applications, and looks like they are about 2 years, very close to 2 years. At least that's the 80%. But I'm gonna select this one as well, the initial issuance, and again looks like it's just a Potomac. Let's see if it's okay, so it's just a little bit faster if it's a replacement. So overall about 20 months. So in your case, if you submitted, if you've been waiting for my renewal card since May 17, 2021. So assuming that May 17, 2021 is the date on your notice of receipt. So the very first notice from USCIS saying that, hey, we have received, we have accepted your application. 20 months, it's almost 2 years from May 17, 2021. We are in 2023, so it's we're almost there, almost been 2 years now. And you probably noticed that in the processing times, it's only 80% of cases, which means there's still 20% of cases that are processed either faster or slower than this, which very well might be the case. But I think you are definitely on the right track. I wouldn't worry about it too much. You have submitted an inquiry, which is great. This is what I would recommend from reading your comment. You have submitted the inquiry already. Your case is still around the processing time, so I wouldn't worry about it too much. But you're still definitely on top of your case, which is great. So hopefully you will hear the response from them pretty quickly. All right, let's move on to the next comment from Nika S8. How many months is maximum is wait time for IR1 visa interview after being DQ by NVC? Okay, so the IR1 visa is the very first preference visa for immigrant visa for U.S. citizens. So if you're a U.S. citizen and you're petitioning for your spouse, that is the IR1 visa, and those visas, as I've described in this video, Understanding Visa Bulletin, if you are in the process of any kind of family related immigration process, definitely check that video out. But basically there is no wait time at all. All of these visas are current. There is no cap on them. They're always available. So once you are documentarily qualified, this is what the DQ stands for, once you basically submit everything to the NVC. So your USCIS part application gets approved, it's transferred to the NVC. Once you submit everything on the NVC part, and NVC accepts it, and they tell you that, hey, that's it, we got everything we need, that means you are documentarily qualified. which means that any moment now you will be invited for an interview to a US embassy to get your immigration visa. In that meantime, when you are scheduled, you will have to do also the medical examination, which is, you want to do it as soon as possible, just a recommendation. But you're almost there. Usually these interviews are scheduled within like month and a half. So anytime now, you shouldn't be waiting for too long. But if you do need to submit inquiry, you can always submit the public inquiry with the Department of State if you think that it's taking long, but I would give it about a month and a half before you do that, because that's usually how long it takes for them to schedule that interview. Because once it is documentary qualified on NVC part, now they actually have to transfer all that information to the local US embassy, tell them, hey guys, you need to schedule the interview, and then depending on what the schedule looks like of the local US embassy, they have a few things to sort out basically. All right, so let's move on to the next question from Sat here. Hi, is it one check for total 540, 370 plus 85 plus 85, or 3 separate checks? Okay, so that was actually a really good question, because I don't think I ever had an opportunity to mention this, but this was posted on I-539. So I'm assuming, Sat here, you're asking this particular fees. You have $370 for the main application, and then I'm assuming you're filling out the I-539A, because there's multiple people on this application, so you're paying $85 for example, yourself, and for whoever it is, the relative that you are filling out the I-539A for. So, okay, to answer your question, in your example, you can definitely submit one check in the total amount of these 3 fees. That's completely fine. Most of the times USCIS, at least as of recently, I started seeing these alerts on these applications. They do not allow combining the fees when you are filing 2 separate applications. In your case, I-539A is not exactly a separate application, it's still a supplemental application. So you should be fine in this particular one. You definitely can do the combined fee. But excellent question. Just keep in mind, verifying if you have separate applications that are not directly related to each other. In those instances, you definitely want to have separate checks for separate applications. Okay, moving further to the question from Chiku94. What about IB1, 4th category based on I-360? And I have B1, B2 visa. Can I travel USA? I was USA, leave without advance parole. Can I travel same? Visa, my visa valid. Okay, Chico, so I'm having a little bit of a trouble understanding exactly your question. But I see that you're in family immigration process based on I-360, and you currently have, so I'm assuming maybe you are not the petitioner, maybe you're the beneficiary because you have the B1, B2 visa. Okay, so whenever it comes to having an immigration process that is going, and if you currently have a non-immigrant status, you can definitely use that non-immigrant status if it allows you to travel back and forth, which B1, B2 visas, they are visitor, tourist visas, so you can definitely use them to travel back and forth, and you are not going to have any problems. Now, the problems that might come up, I wanted to mention here for whoever is watching this video, whenever it comes to having an immigration process, is when you are going to the embassy to apply for non-immigrant visa. That might cause a little bit of problem, and you might be denied that non-immigrant visa. Why? Because you have an immigration process that is happening. So basically, you're planning to immigrate to the United States, and then you go to the embassy and then you say, hey, I want non-immigrant visa to go visit the United States. It kind of contradicts the first one. So that's where you might have those problems. But in your case, you should be completely fine. I'm gonna put this, but I definitely do want to get kind of more information, because you mentioned advance parole, and advance parole usually is for those that already have a legal permanent residence. So a little bit of unclear. If you can clarify with your comment, you can respond to this video. That would be great. I'm gonna follow up with my answer. All right, let's move on to the next one from Da Bombs. Do you fill this application as the petitioner or applicant? I'm confused. Okay, so there is no difference between the petitioner and applicant. Basically, it's the same. If you're applying for something, you're an applicant. If you're petitioning for someone, you're a petitioner, but you're still filling out the application. So a petition, an application, a form, it's really is, at the end of the day, it's all the same thing. It just kind of changes what purpose it serves, right? So if you're applying for employment authorization document, you're an applicant. If you're applying for the video that you commented on, the I-912, which is the fee waiver, you're an applicant, right? And you're submitting the application. With the same kind of, you see where we're going, you can file the application for the, petitioning for your alien relative, and it still is an application because you're applying for a certain status for someone, for your relative, but now you're petitioning for someone. So there's a petitioner, and there's a beneficiary. Beneficiary being your relative, petitioner being you, who is also an applicant. You are an applicant, you are the petitioner. So I hope it clarifies. I'm sorry, this is, I know some of these things, it can be confusing, and some of these things I still get confused sometimes, so it's completely normal, but I hope I was able to answer your question so it's understandable. Okay, let's move on to the next one. From Joe, accountant. My wife's I-130 was approved on 12/14/2022. Congratulations. But she was in US and we did not ask for embassy processing. So they did not send to the NVC. Can I resubmit an I-130 instead of the I-824 form? Okay, so for everyone who's watching, I-824 form is, I don't remember the name exactly of that application, but basically it's the application that you submit if you want the USCIS to take action on an existing approved petition. All right, so it's done in very, very rare cases, because most of the times when your petition is approved, USCIS is taking action by themselves. Most of the times there should be something that happens that somehow puts that application that was already approved in that limbo state. All right, that state where it's just sitting there and waiting. So Joe, to answer your question, take a look at the approval notice that you have received from USCIS. I want to make sure that it specifically says that we did not transfer to NVC, because even if the beneficiary is here in the United States, USCIS does transfer the case to the Department of State. Why? Because whatever status that your beneficiary is here on is most likely non-immigrant status, because you are filing the immigration petition. So they have to actually go and they have to do the whole basically adjustment of status, changing their status from non-immigrant to immigrant status. So regardless, USCIS, they wouldn't just pause your application. One thing that I wanted to mention is, because it was just recently approved, so let's see, like 2.5 months ago, so I'm thinking it still is being transferred to either Department of State or something is happening on your application. I would not recommend submitting anything, especially resubmitting the I-130. Why? Because if you are resubmitting the I-130, you are risking creating that situation where there's a double petition, double application, and you definitely don't want that to happen. I've seen cases where it causes huge confusion. So with that being said, I would highly recommend finding yourself an immigration lawyer and actually calling and having at least a free consultation. Just a free consultation, just to see what a legal advice looks like. But I would also check that receipt notice, that final notice that you received from USCIS saying that your case was approved, and reading the whole thing and seeing what it says, because in there it would say whether your case was transferred to NVC, or if it wasn't, for whatever reason, that it wasn't. So I would, if you can, I would really appreciate if you can come back to this video and respond for additional details, what that receipt notice says, and then from then on I would be able to provide a little bit more information. But let's move on to Marcia S. Can children get an EAD in order to get the Social Security card to be claimed as dependents in their parents' taxes? Thanks for your answer. Okay, Marcia, it's a very, very interesting question. So EAD, if you look at the idea behind the employment authorization document, it's not given for the purposes of Social Security. It is given for the purpose of getting employment. So obviously, if your child is, if they're too young, then there is no point for them to get the EAD or even worrying about getting EAD. The main thing that I would think about is what kind of immigrant status are your children and you are yourself in. Because if you obviously, because you're here in the United States, obviously, and you are obviously working because you're concerned about paying taxes and adding your children there as dependent. So I'm thinking maybe you are either on work visa or maybe you are in some kind of immigration process where you were able to apply for the employment authorization and now you can't work. Either way, if you, from whichever side you look at it, your children should be going as a dependent, whether it's the immigration status or your work visa, and you should be able to apply for the Social Security numbers for your children so that you can, because you have legal right to work in the United States of America. So obviously you will be filing the taxes and you will be claiming your children as dependents. So there should be no need for you to apply for the employment authorization document for your children in order to get the Social Security. Usually you should be able to just get that Social Security, going straight to the Social Security Administration, showing them the current the documents, the immigration documents that show your immigrant status and the immigrant status of your children, and then they issuing the Social Security. But if you can come back to this video and provide more details, what kind of status you're in, I will be able to give you a little bit more detailed answer, but hopefully this helps for now. All right, let's move on to the next one from Giselle GA. Could you please make an instructions for online filing form I-76, which is the employment authorization application, C8 category, which, if I am correct, C8 is pending asylum, if I'm correct. So Giselle, I recommend checking out this video that you commented on. I'm pretty sure in this video, as an example, I fill out for the imaginary person, the example person who's filling out the application, John Doe, as someone who was pending asylum for more than 150 days and now they're applying for the employment authorization document. So check it out, but I can definitely do a separate video specifically just the C8. But again, the difference between C8 category and any other category, the way you fill out the application is literally exactly the same. The only difference is you select the C8 instead of anything else, and then the filing address might be different. But again, in this video, I show it specifically for the pending asylum category. All right, let's move on to the next one from Femi Fawol, and I think we're gonna stop here, and so that the video is not too long. We'll see. I'm from Nigeria, EB2 category, PD, which is the priority date, 16 February 2022. Document qualified 16 February 2023. I am likely to get an interview letter soon. If not, can I expedite my case at the consular because I got a postdoc offer in the US and expect to join soon? Thanks in anticipation. Okay, Femi, excellent question. So basically EB2 is the employment based, all right? And those petitions, they're processed very, very quickly. As you can see, priority dates, very, just a year behind. So these applications, everybody's staying on top of them whenever it comes to USCIS, whenever it comes to the Department of State. So whenever it comes to the interview, you can definitely reach out to your local US embassy and ask them. Just be very professional, obviously, be very polite, goes without saying. It might not speed up the process. Most likely it won't, because really it depends more on the Department of State, because they are the ones who are sending all the information to the US Embassy before they schedule the interview. But it's not gonna hurt. you can definitely reach out. Just don't expect much. If you really want to make a little bit more of difference in this, I would recommend maybe filling out the public inquiry that is available on the Department of State website. Again, though, don't expect too much from it, because most of the times it's just and plus your case is really time-wise, everything seems to be completely fine. So patience really is the only thing that works in situations like this. All right, let's move on to the next one from Naomi Nunes. I'm a United States citizen and got married in Nigeria. USCIS received my I-130, but I have yet received any information for the next step. How long will it take for the USCIS to approve my application? It's been months already and still I have not heard a word. Okay, so you're a United States citizen and you got married in Nigeria. So you're a citizen and you're filing for someone. Well, let's open up our processing times for USCIS. Keep in mind, this is everything that happens on USCIS side, not the Department of State. But this is what the question is about. So we're going to do petition for alien relative. Now, you said that you are US citizen, so we're going to be a US citizen filing for spouse. And depending on which, let's see, did you specify? It's in Nigeria, yes, but I have yet received it. So you don't specify which office you sent it to. So I'm going to select the very first one, California, and we'll see approximately how long it takes. So approximately 10 months, California. Let's do Texas, just to kind of get the average, approximately 11 months. So I would say about a year. About a year, so let's see, when did you apply? It's been months. Okay, so about a year for the processing on the USCIS side. But keep in mind, this is just on USCIS side, because once it is processed and approved by USCIS, your petition is transferred to the Department of State for further processing. So keep that in mind. About a year, and unfortunately, there's also some time you will have to wait, probably a few months, while you're filling out the applications on NVC, the Department of State side. The application for the visas, paying all the fees, providing all the documents that they request, which hold completely separate from USCIS, will take a few months as well there. And then the interview, medical exam, all that good stuff. Yeah, unfortunately it takes time. Okay, so this again, how does it take for Nigeria? Again, it doesn't make any difference. I don't think it is visa bulletin, plus you're a US citizen and spouse. So there is really no, it doesn't really matter which country you are, petitioning your spouse from, because what matters is your status, you're a US citizen, and your relationship to the relative that you're petitioning, which is a spouse, which is first priority. Okay, let's move on to the next question from Chabi Prasad. Good morning. My F3 case was documentary qualified since 18th March 2021. Congratulations. And why is it I'm not getting an interview date? All fee already paid and still I'm not getting an interview date. My PD 11 May 2009, Georgetown, Guyana. Okay, Chabi Prasad. So F3, I have the visa bulletin here pulled up, and if you haven't seen the video that I've made, Understanding Visa Bulletin, I just recently uploaded it. It's called Understanding Visa Bulletin, Why is there an immigrant visa backlog? Please check it out. I think it's going to be helpful. So Visa Bulletin, basically, it shows you the information, the priority dates for when these applications have been filed, and as of right now, which applications are being reviewed from when they were filed. Okay, I'll try to explain it this way. So F3, your category, F3, right? Let me see. Yeah, my F3 case. So F3 is married sons and daughters of US citizens. Married sons and daughters of US citizens, unfortunately, they are, I don't know, don't ask me why, but they are in F3 category, which is a third priority category. And final action dates are from November 2008, and the dates for filing are from November 2009. So there's exactly a year from them. So in your case, you have been already documentarily qualified since March 2021. So if you have been already documentarily qualified, it means that we are looking at this date, final action dates. because the final action date is when you are documentarily qualified by the NVC. So there's nothing else that needs to be done. So as of right now, those who were documentarily qualified are being processed from November 2008, which means there is a backlog for the immigrant visas from 2008 that is 15 years. So there's a 15 years backlog for the immigrant visas issued to the F3 category. So if you have been qualified in March 2021, and assuming that this backlog is not going to resolve and not going to change in the next 15 years, you are looking at about 2036. Yes, 2036, 2021 plus 15 years, where that visa, immigrant visa, becomes available for your son or your daughter, married son or your daughter. Let me see if you are, good morning, my case was done. I'm not sure if you are the son or daughter of US citizen, or if you are petitioning for, if you are US citizen and petitioning for the son and daughter or in Georgetown, Guyana. But unfortunately, that's what the processing times, not the processing times, but the delay on these immigrant visas. And I know it's crazy, and it's a lot of people, unfortunately, are not realizing how much delay there is, how bad it is. And that's why I said, I try to mention in every video now, check out this Understanding Visa Bulletin video. It's to a lot of people, it's eye-opening and very disappointing too, because nobody wants to hear, hey, wait, what? Wait a second, I've went through all of this, and now I have to wait for 15 years to get my son or my daughter? I'm a US citizen. What is this? But unfortunately, that's the case. So there's really not much else I can recommend. I can personally relate. I have someone that I'm waiting for, and it's about another 15 years too for me, that I'll be waiting for that person to get their immigrant visa, which is, I think it's ridiculous. But that's just the way things are at the moment. Hopefully, the only thing that we can hope for is that they speed up, they find a way to process, not process, but issue more maybe immigrant visas, or maybe somehow find a way to, get rid of that backlog. So I'm gonna place that here, and I'm very sorry, Chabi, that I don't have good news for you. Let's move on to the next one, two more, and then I'm in F3 category, already qualified when I get interview live in Guyana. Amanda Libra, wow. Okay, so Amanda, exactly the same question as Chabi. Interesting, also from Guyana. Yeah, so Amanda, unfortunately, again, I don't have good news for you as either. F3 category, that's it. You can. This is by the way, if you're not familiar with this website, this is a Department of State, their official government website, and Visa Bulletin basically is what they issue every single month, and it shows the current processing dates from when the applications were filed. So the difference between these two dates, there's a final action date and there's a date for filing. This date for filing is the date when you receive your receipt from USCIS saying, hey, we have received your I-130. All right. And then this final action date is when you are documentarily qualified by NVC. When NVC says, hey, we received everything, you're good. The only thing that's left is just waiting for that immigrant visa to be available. That's why you see that there is a little bit of dates difference here, like about a year date difference, because obviously between USCIS and NVC, usually about a year, the whole process. But again, F3 category, third priority category, married sons and daughters of US citizens. As you can see, there's only 23,400 visas that are issued a year, which is, I think it's ridiculous, because why is even there a limit for sons and daughters of US citizens? It makes no sense to me, but that's the case that is right now, and about 15 years delay. So let's get to the next one, and hopefully no more bad news. But I think, yeah, you see Sahaj Patel is also asking about F3. What about? It's strange that three last questions in this video. 15 years, unfortunately, Sahaj. There's a delay, And you know what? I'll do another one just so that, hi, I need help, please. Okay, Farida, please provide more information, and I'll be happy. Please provide more. I'll just please provide more information. There we go. And Amanda, I'm gonna finish with your questions here because I have just answered that. Good afternoon. I'm the F3 category, already qualified. Visa bulletin going to move. Yeah, so whenever it comes to visa bulletin moving, what it depends on. So let's say, as of right now, it's November 2008, right? That is the final action date. If this year there is less than this number of visas that were issued, right? The whole total people that are waiting, right, for these immigrant visas, it gets speed up. Let's say this year, instead of speeding up, there's more applications than this number right here. Now there's an additional backlog that from this year that is being added to the next year. So and obviously that's why we have a 15-year backlog, because from all of these past years where the number of applications reached more than the available visas, all the backlog visas they've been transferring to the next year and to the next year and to the next year, causing all of this massive backlog. So I really hope that someone, you know, me, what I can do with these videos is bring awareness and help people and give, you know, some suggestions on what to do in their situations. But I really hope that, you know, someone is actually trying to resolve this, because these dates are not looking good whatsoever. So unfortunately, on this not so happy news, we're gonna end this video because it's been already more than 30 minutes. If you have any questions, any additional follow-up questions, don't hesitate to ask them. I'll be happy to address them. That's why I started this channel. I want to say thank you for all the supporters of this channel, the members of this channel, and those people who use the super thanks feature to, you know, support this channel financially. I really appreciate it. It helps me bring more quality content to this channel, of course, and potentially help more people who need help whenever it comes to the immigration process. So thank you very much for watching. Thank you very much for sticking around. God bless, and I'll see you in the next video.